Civil Procedures Part 1, looking at subject matter jurisdiction. Subject matter jurisdiction is the competency, and here we mean the ability, of the court to hear and or determine a case of a general subject and or class. There is a presumption against jurisdiction. The filing party bears the burden to show that the court has jurisdiction. Federal question, subject matter jurisdiction. This is found in the Constitution, Article 3, Section 2, and in 28 U.S.C. 1331. Federal question jurisdiction is in cases arising under the Constitution, laws, and treaties of the United States. So the court has federal question jurisdiction in cases arising under the Constitution, laws, treaties of the United States. Now, when considering if a federal question has been raised, consider only complaint elements necessary to the cause of action. There is also diversity, subject matter jurisdiction of diversity. This is found in Article 3, Section 2, just like federal question, Article 3, Section 2. Diversity jurisdiction is Article 3, Section 2. This is also in 28 U.S.C. 1332. Federal questions 1331, diversity 1332. Diversity jurisdiction under subject matter jurisdiction. The court has diversity jurisdiction in cases between citizens of different states and for more than $75,000. Certain state actions are excluded, and this includes probate or domestic relations. Now, diversity must be complete, meaning no plaintiff and defendant may be from the same state unless it is a class action and the amount in controversy is greater than $5 million. Now, looking at the amount in controversy and diversity under subject matter jurisdiction, where there is a single plaintiff versus a single defendant, remember you have to meet $75,000. Where there's a single plaintiff versus a single defendant, it is the totality of the claims must meet $75,000. Where there are multiple plaintiffs versus one defendant, you use totality of the claims to meet $75,000 if they are all the same claim. If there is a single plaintiff versus multiple defendants, you use totality of the claims to meet the $75,000 if the defendants are jointly liable. But there's no totality if the claims are separate and distinct. Looking at citizenship of parties in diversity and subject matter jurisdiction, looking at the citizenship of an individual, it's the individual's domicile. You can only have one. This is where the individual is present and manifests an intent to reside for an indefinite period. Looking at corporations and their citizenship of corporations. It is the corporation's state of incorporation and their principal place of business. This is the nerve center test, where officers conduct, direct, control, and or coordinate corporate activities. A liability insurer is a citizen of every state in which it has a client. An unincorporated business entity is a citizen of each state where a member resides. Looking at supplemental jurisdiction under subject matter jurisdiction. And supplemental jurisdiction is not an independent form of jurisdiction. It's found under subject matter jurisdiction, but it is not an independent form of jurisdiction. It is found in 28 U.S.C. 1367. Court may exercise jurisdiction over claims which the court would normally not have jurisdiction if that claim is in common with claims that the court does have jurisdiction, such as federal question or diversity. But the claim which the court will exercise supplemental jurisdiction over must arise out of the common nucleus of operative facts as the claims which have federal question or diversity jurisdiction. Supplemental jurisdiction and permissive joinder. You may join another party, but you may not destroy diversity. Again, these claims must arise out of the same transaction or occurrence or series of transaction or occurrences and have a common question of law and or fact. Looking at counterclaims in supplemental jurisdiction, this is from Rule 13. You have permissive counterclaims. The permissive counterclaim must meet the amount in controversy, but may not destroy diversity. You have a compulsory counterclaim, and that's a defendant counterclaim against a plaintiff already in the action, and they need not meet the amount in controversy, which makes sense because the plaintiff must meet the amount in controversy. You're already in court. Okay. Looking at subject matter jurisdiction and removal. Removal is found in 28 U.S.C. 1441. Removal is the right of the defendant only. The defendant must petition. The court must have subject matter jurisdiction. The defendant may remove to federal court. Again, it's the right of the defendant only. The right is determined based on the pleadings at the time of petition for removal. Diversity must exist at the time of the state court filing and petition to remove, but plaintiff may dismiss an original party prior to petition to create diversity. If removal based on diversity, then no defendant may be a citizen of the state in which the action was originally filed. So you're going to have 1 year to remove it if you're basing it on diversity. That's why you can delay that. Subject matter jurisdiction removal and procedure for removal. You have to file notice for removal within 30 days of service unless you are removing strictly on diversity. You can wait up to a year to remove. The notice must be signed, filed with the appropriate district, contain copies of pleadings and process, served on the defendant seeking removal, provide filing to all adverse parties and clerk of the state court, and if a jury trial is sought by the defendant, notify the federal court as such within 14 days of petition for removal. Again, I mentioned this removal based on diversity alone must be done within 1 year from commencement of the action, unless bad faith by the plaintiff, such as keeping a non-diverse defendant to destroy diversity, then dismissing them after 1 year. And that completes part 1 of civil procedures. And that completes part 1 of civil procedure.